This is a Morrison Solicitors and Hardwick Chambers podcast. Welcome to Property Matters.
Okay, welcome back everyone. This is the second podcast in the Property Matters series. This one is going to focus on the Landlord and Tenant Act 1954 and the right for landlords and tenants to claim interim rent during the course of or at the conclusion of lease renewals. I'm joined as usual by Lena Matson, who is a barrister at Hardwick Chambers, and she specialises in contentious property issues. And I'm also very pleased to be joined for the first time by Nigel Amos from SHW Surveyors. We're going to be talking about issues relating to market rent, and therefore we thought we'd bring in somebody who actually knows what they're talking about rather than have two lawyers trying to explain to people what's likely to happen in the market. So you're very welcome, Nigel, and thank you for joining us.
Thank you. I'm
just going to explain, just by way of further introduction of Nigel. Nigel heads up the professional services team in the London office of SHW, and his principal skills are expertise in all types of commercial property valuation for loan, accounts, tax, and Section 18 purposes, lease advisory, and landlord and tenant transactions. Before we start, I'm going to do what they do in most podcasts and read out some of the feedback that we got from the last one, Lena.
Sure.
Mixed bag of feedback. Lots of requests for subtitles for the Scottish guy. So that's maybe something we can look into, actually, given that we're live on this occasion.
Some of your partners pulling your chain there.
Yes, indeed. Lots of other people questioning whether, Lena, you were in an airport last time, because there seemed to be helicopters taking off in the background. I have tried to explain that was just the very loud sound of your fan whirring.
Not liking the new Windows 10.
Which seems to have stopped today. So
doesn't it?
That's good. And other feedback, again, very constructive, was about background. So I was told that I merged too much into the background. So I've got a plant behind me and some artworks that hopefully give some context. So that's by way of addressing that. Okay, right. So I think the next thing, all we need to do now is crack on. So let's do that.
Okay. So the legal framework. Well, the starting point is that the right to apply for an interim rent, you can find those rights set out in Section 24A to D of the Landlord and Tenant Act 1954. And it's important to remember that the right only exists after a landlord has served the Section 25 notice or a tenant has served the Section 26 notice. So if you just allow your tenancy to run without serving a notice, you will not have a right to an interim rent. You will then just have the passing rent subject to any rent review. This ties in with the fact that the interim rent will be payable from what is called in the Act the appropriate date. And that will be the earliest date that you could have put into your Section 25 or Section 26 notice. So that's normally not less than 6 months, not more than 12 months, and can never be before the end of the fixed term of any lease. What that means is that it can be very important to be quick off the mark and serve your notice if you want to take advantage of an interim rent. Now, the two different methods of valuing the interim rent, they're set out in Section 24C and Section 24D. And very often, the interim rent will just be the same rent as under the new tenancy. But there's some really important exceptions that may be very relevant just now, during and after the COVID crisis.
Thank you, Lena. I will start with Section 24C then, moving on to discuss that bit, that section of the Act. Just to start with, the Section 24C contains an exception to the general rule, and this applies where the tenant is in occupation of the whole of the property and the landlord does not oppose the grant of a new tenancy. So this only applies where there's an unopposed renewal. Now, the general rule, Lena, you mentioned a minute ago, is that interim rent, which we should say is the rent between the appropriate date and the date on which the new lease is entered into, and the appropriate date is the date fixed by the Section 26 notice, that interim period is what we refer to as the interim rent period. And the general rule is that the interim rent is taken as the same rent that is eventually agreed in the new tenancy. So if you agree a new tenancy at £100,000, then the interim rent generally will also be £100,000. But there are two exceptions to that, and the first one is 24C3. And this applies where the interim rent is substantially different from the relevant rent. And what we mean by the relevant rent is the rent which the court would have determined under the legislation had the new tenancy started on the appropriate date. Now, that could be different, and there's a number of reasons why it could be different from the rent that's actually agreed, because you've got to remember that rent is often agreed through negotiations, whereas the interim rent, if you apply the legislation, is assessed by reference to the market standards. Now, what is actually agreed and what the market dictates the rent should be are often very different. So if there's a substantial difference, Section 24C allows the tenant to deviate from the general rule, allows both parties to deviate from the general rule and try and claim a different rent which is more beneficial to them than that which is actually agreed.
So turning to Section 24D, now Section 24D applies to Section 24C does not apply, i.e. where the tenant is not in occupation of the whole of the property or where the landlord has opposed the grant of a new tenancy. Now, in those circumstances, the court is tasked with finding a rent which is reasonable for the tenant to pay. Now, the statute provides that the court has to have regard to the passing rent, the rent under any subtenancy, and also the market rent. But the case law tells us that the overriding principle and the guiding principle is to find a reasonable sum. Now, the court's approach to this has been very similar to what you see in common law in quantum meritus cases. So the court will look at what benefit has been conferred upon the tenant as a result of their occupation. Now, in the COVID crisis, one could see some really interesting arguments, particularly if the interim rent period falls to be during a period during lockdown or any other lockdown we'll have in the future, when the tenant has in effect been excluded from the premises, not by the fault of the landlord, but nonetheless been prohibited from trading from there. I think there's a very interesting argument to say, actually, there has been no benefit conferred on the tenant, and therefore the interim rent should be incredibly low, at least during those periods. But all of this is untested, and for us lawyers to thrash out in the years to come when we look at all these issues.
It's a really good point, Lena. Like you say, completely untested, but it's interesting that it's quite a different basis of assessment, isn't it?
Completely, absolutely.
Reasonableness doesn't necessarily play a part in the, shall we say, traditional method of calculating the rent. So it's, would you say it gives you more scope to argue for a different rent?
Absolutely. So, I mean, the court have also been very clear to say this doesn't give a carte blanche to the court to go off on one. Mm-hmm. I mean, it has to be within a framework, and the framework is set by Section 24D. But the court has also said, we're not just looking at, it's not Section 24C. We're not looking just at passing rent and market rent. We're looking at more factors.
Yeah.
And therefore, there is great scope for discretion, which means that there's a lot of scope for litigation, particularly if you have high value properties, and you might be able to reduce your rent by 80%.
Yeah. Nigel, what do you think? Do you think this idea of reasonableness and lockdown periods, do you think there's a huge scope for arguing that as a factor for adjusting rent?
Well, undoubtedly COVID is exercising everybody's mind in the valuation field.
Yeah.
Not all property sectors are necessarily affected in the same way, of course. And we have to distinguish between different markets where perhaps COVID is not having a massive impact on values, such as perhaps industrial warehousing. We also have to bear in mind that regionally, things are different as well. So it's something where you shouldn't really generalise, but from the point of view of retail and hospitality, which have been the obvious property sectors that have been directly impacted by the lockdown, then there is going to be a very interesting period, I think, probably September onwards, in terms of where values are going to settle down to. And depending on which side of the fence you're on, there's a lot of trepidation and consideration that now needs to be put into lease expiry events and the tactics that play out from that, which obviously includes the consideration of an interim rent.
Nigel, I should just say, Nigel, I brought you in a little bit too early there, I think. So I've moved the slide along because we've moved seamlessly into expert evidence. So please do continue. But could you just explain just why September is a relevant sort of period from which we can start looking at the market?
Well, in September, I believe there's been nothing announced by the government about extending the moratorium on landlords taking possession proceedings. But also the actual impact on values hasn't filtered through necessarily yet, because we're still in the very early stages of the pandemic and what impact it's going to have. We've obviously had the 4th of July, where the hospitality industry and some of the retail industry can get back going again. But until we get actual transactional evidence occurring, we still don't know what direct impact there's going to be.
Yeah. But
from September onwards, I would imagine there'll be a big shakedown in terms of what tenants have survived, what the shape of different markets are going to be, and a lot of sort of rent concession agreements that have been to deal with the shutdown have mainly been over a 6-month period. So everybody is thinking that from September onwards, the market's going to return to normal. But of course, when it returns, who's going to be there to occupy property, and at what appetite and what bidding levels are they then going to re-enter the market?
It's interesting, we're getting off topic here a little bit, but you mentioned rent concession agreements there, Nigel. Has there been quite a big uptick in those then in your area?
Well, what happened was in March, everybody was thinking this crisis was just on for 3 months, and a lot of landlords played a part with the tenants in reducing rents for a temporary period, not realising 3 months on that the struggles in some of the markets are still there, and we've all had to rethink again about whether rent concessions are still appropriate for the June quarter period, which obviously takes us through to September.
Yeah. No, good. So lots of uncertainty then, and really just a case of watch this space.
Until we get actual evidence, it's difficult to actually say. I could though give an example where you've got to be careful about necessarily assuming rents are going to go down.
Yeah.
And that's in a situation, for example, I do a lot of work acting for tenants in Chinatown. And I only act for tenants there simply because I don't want a conflict of interest trying to prove rents high or low, but generally I act for both parties in wider areas. But Chinatown is a very specific area. And there, over the past 5 years, so 2014 through to 2019, rents have been rising by approximately inflation rates, so between 12 to 15% over the 5-year period. So if I was faced with looking at a rental value for maybe September or December this year, and trying to analyse where the market had gone to, I would have to take into account the fact that there's perhaps a 15% catch up in rent before, from the passing rent through to the current values, before then applying any discount that might be applicable as a result of a falling market. So if the market's fallen by, say, 25%, then the reasoning would be that your rent would perhaps go down approximately 10%.
Yeah, what you mean?
Because you've already got the 15% catch up.
Yeah.
So it's important to know where the level of value of the passing rent is before assessing whether or not the new rent will go down.
Yeah, no, that's interesting. You know, these are the sorts of things. This is why we brought you on here, Nigel, because you know, it's easy for us to just assert that we think rents are going to go down, but that's interesting. It's all very nuanced, and yeah, no, that's interesting. Thanks for that example.
I'm really curious, Nigel. What if you had to guess the future? What do you think the market looks like in the next 5 years, and maybe inside and outside London?
Yeah, that is a massive question.
Sorry.
And in particular because the property sectors are acting very differently to COVID. Just going back to industrial and warehousing, within the M25, there is increased demand for properties, not just changing as a result of COVID, but simply because the way in which distribution and storage has occurred before COVID. For example, we have this last mile requirement where you need a smaller warehouse within the M25 for big lorries coming in and then vanning the contents into central London. I mean, that's driven high demand, and that demand, I think, is still there despite COVID. But when you actually look at retail and hospitality, it's been so directly affected by forced closure that inevitably there's going to be massive issues that have already started and will pan out for the next, I don't know, at least 24 months as to where it's all going to settle down. Retailing has been really under pressure from e-commerce. It was already struggling a bit with the announcement of Brexit as well, and uncertainties about where we're going on that. And COVID has come along and really dampened things down even more. Look, most property investors I doubt whether many would predict where the market's going to go or take a punt on where the market's going to go. And that includes property investors in residential markets as well. It's so uncertain at the moment.
And what about office space as well, with people working from home and that sort of thing?
Well, it's interesting on offices. The general view is that the movement towards working from home and more flexible working and reducing perhaps the requirement for offices has been something that's been in the market pre-COVID and probably would have developed over a 3-4 year period to where we are now. But of course, what COVID has done is seems to have squeezed the thinking towards this more flexible and working from home prospect into a 3 to 4 month period. So we've literally had to adapt within a massively short scale from what was probably around the corner and going to happen anyway. And the challenges that has brought us as generally, I suppose, factored into to most companies thinking that they now have the technology and they have the confidence in staff working from home and being able to be as productive as if they were in the office, which goes on to suggest that there's going to be less demand for offices in central London, central districts, whether it's London or Birmingham or Manchester. Now, it's untested. We don't really know where it's going to go. There's a lot of people saying there's a shortage of offices in London, which would mop up the less demand. Other people are saying that this is so dramatic, the way that things have changed, that there might be a movement towards creating hubs outside of central London districts, where you haven't got to rely on public transport to get in, and you can cycle or walk to a hub where you can have proper office facilities. Other people are saying, well, working from home is all very, very well, but you need the interaction with colleagues. If you've got junior members of staff who are supposed to be learning off you skills of the trade, they can't do that working from home because they're not sitting next to you or near you. So there's a myriad of things to consider in the office market.
I'm one of those people that misses the office and the interactions, so certainly can sympathise with that. Good, thanks, Nigel. That's really, really interesting, and it sort of brings us neatly on to the next area of discussion, which is how to either make the most of it or whether spot opportunities for recovering or claiming or mitigating against interim rent applications, and in such a turbulent and uncertain market. So we'll go on to discuss that now. Bringing it back to tactics and why we think this might be relevant, I'm just going to recap the reminder that the general rule for interim rent is that the interim rent is usually assessed by reference to what rent is agreed between the parties. The exceptions which come into play allow you to differ from what is eventually agreed, and that is why market considerations and other external factors are relevant. So when we talk about tactics, we're talking more about whether or not there's an opportunity to benefit from the exceptions and deviate from what is eventually agreed between the parties in terms of rent. So, Lena, one of those factors then, I suppose, is the effective delays. So, why is that relevant?
Well, regrettably, with the pandemic that we had, the courts have closed.
Yeah.
Lots of court staff have been furloughed, and generally there's been lots of suspension of lots of court hearings. Who knows when things will be up and running properly again? And I would anticipate that if you issue a claim now and you need a 2 or 3 day trial, it might be 2 years in London court before you get a hearing. And with that in mind, there might be a lot of scope for arguing that the rent, which is ultimately either agreed or determined by the court at that court hearing, will be either substantially different from what the rent should be during the 2 year, but you have an interim period.
I suppose what you're saying is the longer the interim period, the more likely there is for fluctuations and external factors to play a court, and that period is affected just because of the court being clogged up with cases and the delay in getting a hearing.
Absolutely, and particularly the effect might be substantial because you have all the turmoil in the market during this delay.
Yeah.
So it'd be very interesting to see what happens in a couple of years with cases which have been pending determination, and to what extent the delay will be taken into account by the court.
I've just so explain, Lynn, if you don't mind, like what then is the motivation for the landlord? What's the landlord looking for in terms of the market and how to make the most of interim rent, and what's the tenant looking for in terms of dips in the market?
So when the rents are not falling, ordinarily only a landlord will benefit from making an application for interim rent, and they usually will do.
Yeah.
What they then ask for is that the new rent, which is higher, will be backdated to the appropriate date, i.e. the date that you could put into the section 26, 26, 25 notice. So you'll backdate it maybe by a year or 2. That's always in the landlord's interest when the rents are going up.
Mm-hmm. Cool.
When the rents are going down, and ultimately you have a lower rent being agreed, then it will be in the tenant's interest to ask for the interim rent, because then they will reduce the rent under the old tenancy, which they otherwise be paying for the period of negotiations or while you wait for a court hearing.
I think it's also important to stress that when we talk about backdating of rent is usually something that's negotiated without any reference to interim rent and exceptions in Section 24C. One thing I wanted to get across here is that this is a statutory right for tenants and landlords to force the backdating of the lease in order to reflect their entitlement to interim rent. So although it's primarily a negotiating point, and Nigel, you and I were discussing this earlier, that it's underpinned by a statutory right. So it's something that's definitely up for grabs in the negotiations. Whether you pursue it all the way to a court or not is an entirely different matter. But the fact that it's underpinned by a statutory right to interim rent is something to be, be aware of in the negotiations.
Absolutely. Something that I've seen on quite a few occasions is that parties will negotiate and agree a new lease. No one makes an agreement in respect of interim rent. And then the landlord, because the market has been going up for the last few years, applies for the interim rent based on the new rent under the new tenancy. So they will then get that new rent backdated for a year or two.
Yeah.
And that was never part of what the tenant anticipated when they agreed the new rent.
This is where that's a good point. This is where I think it gets interesting, because with my experience, interim rent, backdating of rent, and then Nigel, you probably agree with this, is it's often something that's just dealt with at the end, at a point of completion. It doesn't feature too heavily at the start or throughout negotiations. Would that be fair to say?
It's true. Interim rent applications, interim rent considerations are not the primary focus usually of a lease renewal discussion. Generally, I suppose, because the market over the period of negotiation is not massively volatile, whether it's falling or going up. It's incremental, over a period of 3 to 6, 9, 12 months. But obviously what we're faced with at the moment is complete drama by comparison, and the potential for the market to react in a massive and drastic fashion, as opposed to the usual more sort of gentler movement in value, whether it's up or down. So,
and this is why I think it's interesting, because whereas before it's been treated as a bit of an afterthought, I think parties should, in 2 years' time, 12 months' time, should be looking over their shoulder and thinking, well, that was a weird few months. That was a weird year for the market. Maybe we should. Maybe the exceptions are relevant. Maybe we don't have to accept the agreed rent as the interim rent, and that's why all the considerations and permutations, Nigel, that you were talking about previously, come into play. Because, I mean, we don't know yet. Of course, we don't. But there could be some weird fluctuations, and that could benefit one party, not the other. So, I guess, it's potentially a long way off before all the information comes through and before the decision can be made. But one of the
it's certainly not beyond credibility of some sectors and some markets collapsing completely, and it's not just about the general levels of demand. It comes back to different social factors affecting the way in which COVID is making us sort of reappraise how we go about our business. And one of the most severely affected markets at the moment is shopping centres. And in those circumstances, it's been extremely tough for landlords to maintain or retain rather tenants who have struggled recently. And of course, once you start to get tenants moving out of an enclosed environment, then it becomes less and less attractive, and there's sort of a snowball effect. And do people want to be in an air-conditioned, closed environment anymore? I mean,
good point. Good question.
But then of course, you've got to look at, well, maybe some of these properties will be repurposed, where demand goes off in a different direction completely. It's just such an unknown at the moment. I think the general perception is, though, it's going to be a very challenging time to think that the normal normal pattern of rent growth is going to stay the same. I think it's going to take a step back and massive reappraisal.
Yeah.
It seems to me that the general point that I hope viewers will take away is whether you're a landlord or a tenant, and regardless of the sector that you're in, you might benefit to take some advice on whether you're in a position to serve notices, whether you should serve notices, whether you should be applying for interim rents, whether you want to control the process, or whether you want to try to avoid notices being served because you are really happy with the passing rent.
Yeah.
And getting the timing right. Because in this volatile market, as you say, Nigel, lots of things are up for grabs, and tactical considerations, I think, will be more important than ever. So advice is something that most landlords may want to seek early.
Yeah, very good. Yeah, I mean, that's just a good little wrap up. You know, the title of this podcast is now the time to serve your notice to preserve your position on interim rent. I think the conclusion is get advice before you do anything.
Absolutely.
It's a complex area. Get advice from a solicitor or a surveyor, and there's lots to think about. And so, yeah, I think that's the short answer. So I think we could probably wrap up at that point. Don't you agree?
Fantastic.
Yeah, good. Okay. Listen, I hope that was helpful for everyone. I certainly enjoyed it. It was really good, Nigel, to have you and have a different perspective on things and try and focus away from the legal side of things. Interim rent is an area it's not frequently encountered, plays a small part, but it's one that certainly Lena and I see as something that's going to feature more heavily in lease negotiations and possibly even court proceedings. So watch the space.
Absolutely.
Thank you.
Thank you.
Yes, Des.
Thank you.
Okay.
Bye-bye.